Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to the View from Mayor Brown Employment Podcast. This is our fortnightly podcast series on matters dealing with employment law in the UK of general importance to employers. In addition to our fortnightly series, of course, we also do occasional one-off guest episodes. And I'm delighted to say that I'm joined again today by Miriam Bruce, who is the Senior Associate in our employment team. And what we're looking at 6 cases that we think are going to be of significance during 2018. And in keeping with the New Year theme, we've called this New Year Resolutions. So Miriam, welcome to the podcast.
Thanks very much.
And you decided you were going to do the first case, yes?
Oh, yeah, I'm going first this
You're
time.
going first. Okay, go for it.
So the first case I've picked is one which appears to be heading to the European Court of Human Rights, and that's the case of Matu and United Kingdom. This case deals with the question of whether the right to a fair hearing in Article 6 of the European Convention on Human Rights applies to internal disciplinary proceedings. So long-term subscribers to the podcast who have very good memories may remember this case from Nick's 2012 podcast series when it was at Court of Appeal stage. I think, Nick, that was your 3rd ever podcast. So
Yes, obviously my memory is not sufficiently good that I can remember doing this, so I'm all ears, Miriam.
Sure, so let's remind ourselves of what happened at the Court of Appeal. So Article 6 guarantees that individuals have a right to have civil rights and criminal charges determined by an independent and impartial court or tribunal. Broadly speaking, Article 6 can be relied upon directly by employees of public sector employers and indirectly by employees of a private sector employer, for example in determining whether or not there's been a fair dismissal. In cases prior to Matu, Article 6 had been relied upon to entitle individuals to legal representation at internal disciplinary proceedings. The Court of Appeal decision was therefore significant in giving an appellate view on the applicability of Article 6 in this context. The case concerned a number of issues, but I'm going to focus on the claims made in relation to Article 6 only. The facts are very straightforward. The individual, Matu, was suspended for a period. Once the suspension had been lifted, he returned to work. The employer sought to specify a reskilling programme. Mr. Matu didn't comply with this and eventually faced disciplinary proceedings for his failure to comply. These eventually resulted in his dismissal. Mr. Matu claimed that Article 6 applied to his disciplinary proceedings and had been breached by virtue of the fact that the panel was not independent and impartial. The Court of Appeal, by a majority, decided that Article 6 was not engaged. An employer issuing a decision to dismiss is exercising its rights given under the contract. The employer is not purporting to act as a judge and is protecting its own interests. The majority of the court felt at this stage, i.e. at the internal disciplinary stage, the dispute is not being determined in a quasi-judicial way. If the actions are later challenged in a court, it is at that point that a dispute has arisen, which is determined by a judge, and at that stage Article 6 would be engaged and complied with by virtue of having an impartial court or tribunal dealing with the matter. Now, Mr. Matu argued that the effect of the employer's decision to dismiss would be to rule him out of the ability to practice his profession. This was based heavily on an earlier case called Kulkarni, where the Court of Appeal had commented obiter that if the effect of the employer's decision to uphold the charges was such as to debar the individual from carrying on their profession, then Article 6 could be engaged. The Court of Appeal in this case, however, found that this allegation did not stand up to a factual analysis. However, crucially, the court went on to say that the factual consequences of a decision to dismiss were not relevant. It was either a decision which attracted Article 6 rights or it was not. So in this case, deciding whether the employer had to comply with Article 6 before dismissing could not depend on the actions of other employers in deciding whether or not to hire the individual subsequently. Article 6 was concerned with legal rights and obligations, and its application would not vary depending on the particular facts of the case. Otherwise, this would give rise to considerable uncertainty and the obvious opportunity for legal challenge. Pausing here, I think this makes sense and avoids all sorts of hypothetical cases as to what might happen if dismissal occurred. An earlier Supreme Court decision in R and G had, in the Court of Appeal's view, made an assumption that Article 6 might be engaged without having considered definitively whether rights were being determined by the employer when dismissing the employee. So it did not compel the Court of Appeal in Mattu to take the view that Article 6 was engaged. I think the Court of Appeal decision in the Mattu case was a very helpful one for employers, particularly who are seeking to avoid having employees represented by lawyers in internal disciplinary hearings. Equally, if an employee was able to insist that internal disciplinary hearings were independent and impartial, this would lead to considerable problems for employers, given that any disciplinary panel made up of employees employed by the employer would be unlikely ever to be viewed as independent. Following Mattu, there may still be exceptional cases where it's appropriate to allow an individual to have independent legal representation. The classic example was where an individual is disabled, and either as a matter of general fairness or as a reasonable adjustment, the individual should be permitted to be represented by a lawyer at the disciplinary hearing. However, if this case is right, such examples would be very much the exception to the rule. So in terms of why this is one to look out for, we understand that Mr. Mattu has appealed to the European Court of Human Rights on the Article 6 point. So I think it will be very interesting to see if they take a different view to the Court of Appeal, and there'll be potentially significant consequences for employers when it comes to representation for employees at internal disciplinary matters if they do.
You can see that would transform the internal disciplinary procedures if that case went against the employer.
I agree. I don't think adding lawyers to the mix is often a good idea. Exactly. So no. I think this is definitely one for us to keep an eye out for.
Yes. I think it would transform the grievance and disciplinary processes. You could see.
Yeah, but I think Mattu was a sensible decision.
Yeah.
And
well, you can see exactly the logic of what the Court of Appeal is saying. Yeah. Okay. All right. So shall I go do my first case, which is the various claimants and Morrison's supermarket case, which is a data protection case, which I think has got implications for all employers. And I've touched on it previously, in fact, in a recent podcast, so I'll deal with this relatively briefly. You remember from that previous podcast that at the end of last year, the High Court decided that Morrison's was vicariously liable for deliberate and criminal disclosure by a rogue employee of personal data belonging to co-workers. The individual in question was a senior internal auditor for Morrison's, and as part of his role, he was entitled to have access to some personal data about employees. Some of this was sensitive personal data and was confidential. He became disaffected for various reasons, and a couple of months after this had happened, the external auditor, KPMG, asked Morrison's if they could have certain payroll data for audit purposes. The individual in question, the rogue individual, was asked to handle the transfer of data by Morrison's, and this data was originally stored on a secure system. The data was then extracted off it to give to the individual, to give to the auditors. He didn't have the right to access the data originally, but he took the encrypted USB stick, which he was given. He then downloaded it onto his own work computer before then loading it onto another USB stick and forwarding that data onto KPMG, as he'd been asked to do. But crucially, of course, he didn't delete the data that was sitting on his computer. A couple of weeks later, he uploaded all the data onto the web, posting it under the name of another employee. He is currently doing time for fraud, but more importantly for the purposes of our report, what about the rights of the individuals whose personal data had been wrongly, deliberately disclosed by a rogue employee? Well, they brought claims against Morrison's, arguing that Morrison's was the data controller and that this was a significant security breach, and as such Morrison's were liable. Alternatively, if Morrison's wasn't the data controller, they said he was vicariously liable for the wrongful actions of the employee. The High Court accepted that Morrison's was not the data controller at the point at which the information was being loaded by the individual onto the public website. The individual controlled the data, the individual was deciding what to do with it. Similarly, although the court accepted that perhaps Morrison should have been more hands-on in ensuring the security of the personal data, this didn't actually cause the loss. The individual would have set out to circumvent any and all precautions, given that this was not an inadvertent breach by the individual. It was deliberate and knowing breach, designed to cause problems for Morrison's. So that left the claim for vicarious liability. The judge accepted the concept of vicarious liability existed under data protection legislation, and also that an employer could be vicariously liable for the misuse of private information or breach of confidence doctrines. The test for whether an employer is vicariously liable for an employee's wrongful actions was laid down in cases such as Lister and Hesley Hall Limited, and the key question: is there a sufficient connection between the employee and the wrongful actions such that it would be just and fair to hold the employer vicariously liable? Here, the court accepted that there was a sufficient connection and that Morrisons were therefore vicariously liable. The individual had been given access to the data through his work. He'd been deliberately entrusted with it by Morrisons. He'd used another employee's data to post the information falsely on the web. His motive in publication was not relevant to the decision as to whether or not there was vicarious liability for Morrisons. Well, the case is continuing. Obviously, the High Court's going to need to go forward and assess damages, but bearing in mind that under the Data Protection Act 1998, it's not necessary for the claimants to show any loss. Individuals can claim for distress merely from the disclosure of their data. This case has got worrying implications for employers. There's no two ways around it. Here, an employee deliberately set out to break the employer's systems and cause problems for the employer. This is about as far away from any act that the employee was authorised to do as it's possible to imagine. And that's the normal principle used to base vicarious liability as a theory on. But what's an employer to do about this risk? Although the company could have been more hands-on when it came to deleting information from the individual's own computer or ensuring that he did it, the court found that Morrisons' actual failure didn't give rise to the loss. In other words, Morrisons in reality have been extremely unlucky and are being asked to carry the can, although completely innocent of any actions giving rise to the damages. Equally, as the court is aware and acknowledged in its judgment, given that the employee's actions were designed to cause problems for Morrisons, the court, bypassing liability to Morrisons, is actually furthering the employee's wrongful aims. Given that we're talking about something like 100,000 employees of Morrisons, the potential damages could be significant in total. Morrisons has been given leave to appeal to the Court of Appeal and understandably has indicated it's going to do so. It'll be interesting to see how the Court of Appeal reconciles the outcomes of the High Court decision and the idea that when the data was loaded onto the web, Morrisons was not the data controller, but the individual was still acting in the course of his employment when disclosing the information to the outside world. So that's the case of various claimants and WM Morrison Supermarket PLC, and I'm quite sure, assuming that gets to the Court of Appeal during the course of this year, that will be back on the podcast again at that point.
I think I felt very sorry for Morrisons in this case. I think it shows that, you know, with GDPR coming in, I think the focus is really going to be on protecting individuals' data rights at almost any cost, and the employer is just an unlucky victim.
Yes, if there's a security breach, and you're liable. Someone has to pay for it. Someone has to pay for it. Yes. I suspect that's where that's heading. Okay, what's next?
So my next case, apologies for a very poor quality Spanish pronunciation. This is the case of Porras Casido and Bankia SA, which considers at what point a pregnant woman benefits from protection from dismissal in a collective redundancy scenario. In terms of where we are with this case, we've just had the Advocate General's opinion and we're waiting for the ECJ's judgment. So let's remind ourselves of what happened in this case and what the Advocate General said. Again, the facts of this one are very straightforward. The claimant was dismissed as part of a collective redundancy exercise based on the ranking she achieved following a selection process agreed with the employee representatives. She was pregnant when the employer dismissed her, and her employer claimed that it was not aware of her pregnancy at the time of dismissal, as the claimant had not notified them. The claimant brought a case disputing her dismissal, and the case went through the Spanish courts to the ECJ. Our review of this case is going to focus primarily on whether an employer needs to know that an employee is pregnant in order for the employee to be protected from dismissal under the Pregnant Workers Directive. The Advocate General's non-binding opinion, which we had last year, was that workers are protected against dismissal under the Pregnant Workers Directive from the beginning of their pregnancy, regardless of whether they've informed their employer of the pregnancy. The Advocate General acknowledged that there was a tension in the law here. Article 10 of the Pregnant Workers Directive says that member states must take necessary measures to prohibit the dismissal of workers during the period beginning with their pregnancy to the end of their maternity leave, save in exceptional cases. However, under Article 2A of the directive, a pregnant worker is defined as someone who informs her employer of her condition. The Advocate General was of the view that this tension had to be resolved in favour of the individual, such that the individual benefits from protection from dismissal under the directive as soon as she becomes pregnant, not from the point she tells her employer. Now, the Advocate General acknowledged that this means that an employer may unwittingly dismiss a pregnant worker whom they ought not to have dismissed. However, once the employer knew of the pregnancy, they would have had the opportunity to rectify the damage, either by reinstatement or by reopening the dismissal procedure and following the steps that they should have taken previously. In fairness to the employer, the dismissed employer would have to notify the employer of her pregnancy without unreasonable delay. The Advocate General also considered in this case that the dismissal of a pregnant worker in a collective redundancy situation will only be justified if there's no plausible possibility of reassigning her to another suitable post. Employers should also give pregnant workers detailed reasons explaining why the dismissal is justified, as an exception to the rule that the dismissal of a pregnant worker is prohibited. I think the conclusion on the redundancy point, i.e. that a collective redundancy exercise cannot, in itself, be used to justify the dismissal of a pregnant worker, is relatively unsurprising. What's more surprising, I think, is the view that individuals benefit from protection from dismissal as soon as they're pregnant, even if they've not informed their employer. Under UK law, pregnant employees are only protected against discrimination and dismissal where their employer knows of their pregnancy and acts unlawfully as a result. So I think it will be interesting to see how the ECJ approaches this issue and what the ramifications might be for UK employers.
I think there are two parts to this. The first bit, I think the idea that employers are guilty of discrimination when they don't know that someone is pregnant is somewhat counterintuitive, to be neutral. And of course, if you have discriminated against someone, they are under no obligation to forgive you. So they tell you, oh, by the way, I didn't tell you I was pregnant, but I'm not coming back to work and you've dismissed me on grounds of discrimination, so I have a damages claim. So I think that part is
tricky.
Very tricky. And article does define a pregnant worker as someone who informs the employer of her condition. So
seems pretty clear.
Seems pretty clear to me on that one. But the other thing is, a collective redundancy exercise in itself cannot be used to justify the dismissal of a pregnant worker. Yes, but we've got special protection whilst an employee is on maternity leave that gives individuals enhanced rights, but there's nothing before they go on maternity leave. And a collective redundancy is a non-discriminatory reason for dismissal. So whilst in practical terms you might say, well, you've got to make sure your selection criteria aren't indirectly discriminatory or something like that. But again, I think at the moment under English law, you would be saying, provided there is no link between the dismissal and the pregnancy, a woman, before she goes off maternity leave, has no extra protection.
So, I think it could change the position in the UK on that as well. Yes, that's true.
Yes, interesting. Okay, my second case, Boxer and XL. This is a gig economy tribunal case, but it's a different case. It's a different sort of gig economy case. This case does not look at status issues as we've dealt with in things like Uber, Pimlico Plumbers and so on. Instead, this case looks at whether worker status transfers under TUPE. So the fact that it's a gig economy case is really maybe a little bit misleading. Anyway, so this is Boxer and XL, or City Sprint, which is coming up for a preliminary hearing at the tribunal next month. The claim relates to an individual who last year successfully claimed worker status against XL. But, despite the ruling, City Sprint, which acquired XL, has continued to engage the individual as an independent contractor and not a worker. In other words, they're saying that finding doesn't bind them. In the present case, we understand the individual is seeking a ruling that his worker status transferred to City Sprint under TUPE. The reason I think this case is one to watch because it's the first case that I am aware of which would actually address head-on whether workers are covered by the TUPE or whether it's just limited to employees. Under Regulation 4.1 of TUPE, anyone, quote, employed by the transferor and assigned to the organised grouping of resources or employees that is subject to relevant transfer, which would otherwise be terminated by the transfer, unquote, will transfer. Under Regulation 2.1, there's a definition of employee. And an employee is defined as any individual who works for another person, whether under a contract of service or apprenticeship or otherwise. And it's those words "or otherwise" that cause a certain amount of head scratching. And I know in the past that we've had to advise on situations as to whether an LLP member, an equity partner in a law firm, was an "or otherwise" for the purposes of TUPE. Given the wide definition of employee, it would seem logical that workers could be caught by TUPE. So it's going to be interesting to see what determination the tribunal comes to on this point. Of course, even if the tribunal confirms as a matter of principle that TUPE can apply to workers, it may not apply on the facts here. For example, if the other elements of TUPE are not satisfied, so, for example, the individual maybe wasn't assigned to the organised grouping of resources that is the alleged subject of the transfer. Who knows? But all of that, of course, will be fact-specific, whereas a finding that a worker was covered by TUPE regs would, of course, be significant. I also understand the case will consider whether Section 1 of the Employment Rights Act 1996, which says employees have to provide staff with all employment particulars, with a statement of employment particulars within the first 2 months of employment, whether that applies to workers as well as employees. And clearly, if that's held to be the case, that will be an administrative burden for those engaging workers. So, whilst the case may not grab the headlines in the way that other gig economy cases have, I think this is a one to watch because it's actually got significance far outside the gig economy for TUPE transfers and the way companies treat workers.
I think it really, if they go with this, I think it really blurs the line between employee and worker. If you've got to start putting your workers into TUPE consultation and so on, it's really going to be quite a big change for some.
Well, certainly what we've
employers.
done in the past, I know, is where we've had workers, and we've been aware of this as a legal issue for some time, is you often go through an analogous process, but it stops short of being actual consultation, but you do provide information. Yes, I think it's going to be quite a challenge for companies. So very interesting to see the way that one goes.
So the next case I'm looking at is a case of Donnellan and Liberator, which looked at how far an employer has to go to satisfy a tribunal that it's done enough to determine whether an individual has a disability. The case was considered by the Court of Appeal at the end of 2017, and we're awaiting its judgment. The facts of this case were that the claimant was dismissed for persistent short-term absence and for failure to comply with absence reporting procedures. In the last year of employment, the claimant had had over 120 days absence for numerous reasons, including stress and anxiety, hypertension and a number of viral conditions. The employer sought an occupational health report and posed a number of questions to occupational health. The report said that the individual was not disabled, but did not answer the specific question which the employer had asked. The employer did follow up and got a more detailed report, but still occupational health did not answer the specific questions posed. There was no further engagement with occupational health by the employer, but the employer did meet with the claimant to have return to work discussions and to learn more about her various ailments. It also reviewed correspondence with her GP. A couple of months after the occupational health report, the employer dismissed the individual. The claimant then brought a number of claims, including one for failure to make reasonable adjustments. At the tribunal stage, the tribunal held that at the time of the occupational health report, the claimant was not disabled, but she was disabled by the time of her dismissal a couple of months later. It was accepted that the employer did not have actual knowledge that she was disabled at the time of her dismissal. The question, therefore, was whether the employer had constructive knowledge of her disability. In a claim for reasonable adjustments under Section 20 of the Equality Act, employers are required to have actual or constructive knowledge of disability in order for the duty to make reasonable adjustments to apply. At the tribunal stage, the claimant's claim for reasonable adjustments was rejected. The tribunal said that the employer did not have constructive knowledge of the claimant's disability and so was not under a duty to make reasonable adjustments. The claimant appealed to the EAT on two key grounds. First, she said the employer had been too reliant on the occupational health report, which had said she was not disabled. Previous case law, namely the case of Gallup and Newport City Council, made it clear that an employer has to make up their own mind when determining disability and not blindly accept the occupational health opinion. The second ground of appeal was that the claimant said that the employer had not done all it reasonably could to determine whether she was disabled. The EAT rejected the claimant's appeal. It found that, as a matter of fact, the employer had not relied blindly on the occupational health report. Secondly, the employer had done enough to escape constructive knowledge of disability. In particular, even though the occupational health report was flawed, as it was incomplete, it was important that the employer had discussed the matter with the claimant subsequent to the occupational health report and also reviewed further guidance from her GP. Helpfully, the EAT confirmed that the test for how far an employer should go in a situation like this is not that they need to make perfect inquiries as to the individual's disability, rather that their inquiries need to be reasonable. So in my view, the tribunal and EAT decisions were helpful for employers, particularly when dealing with difficult or obstructive employees and where there's an issue with persistent absence with multiple causes, as was the case here. It's also helpful that the EAT has confirmed that the standard of inquiry which an employer needs to carry out when determining whether an individual is disabled, the test is, has the employer acted reasonably in its inquiries and made reasonable efforts? The case has been appealed to the Court of Appeal and it was heard at the end of the last year, so it will certainly be one to watch, in particular whether the Court of Appeal gives a different view on what is expected of employers who find themselves in a similar situation.
It's quite difficult for employers if the employee isn't cooperating or, as you said, multiple different reasons are being put forward. And in fairness, the individual themselves may not have a complete medical picture themselves. But yes, I think if the standard is moved or the standard is increased so that more is expected of employers, that will be problematic, I suspect.
I agree.
Okay, so my last case, which I think is a particularly novel one, it's the Independent Workers' Union of Great Britain and the University of London, which hit the headlines towards the end of last year when it was launched. And when we did our original run-through of this, it was still a case in progress. But unfortunately, the Central Arbitration Committee has been peskily effective and efficient in sorting it out. So actually what we have is a decision in this case, although, for reasons I'll explain, I'm not sure we've heard the end of it. This case, which as I say has just been decided by the Central Arbitration Committee, looked at whether outsourced workers had a right to bargain collectively with a de facto employer as well as with their actual direct employer. The case was brought by the union on behalf of various workers, security guards, receptionists, who work at the University of London but who are not employed directly by them. Instead, these individuals are employed by a facilities management company following outsourcings by the University of London. The union claimed that those workers should have the right to bargain collectively over pay and conditions directly with the university as the de facto employer. This was primarily because it was the university, as the ultimate end user of their services, who substantially determined the terms and conditions of employment for those individuals. To deny the individuals the right to bargain collectively with their de facto employer was, according to the union, breach of Article 11 of the European Convention of Human Rights, which protects the right to freedom of association and assembly. Under current UK law, Section 296 of TULCRA, workers are only able to bargain collectively with their direct employer, i.e. the entity with whom they have a contract. Well, if the case had been successful, I think it would have had colossal implications for thousands of workers, employers and service companies, as it would have meant collective bargaining with two employers. In addition, it would also have potentially undercut one of the key benefits of outsourcing for the customer, which is the ability to save time, money and costs associated with the staff assigned to a function. Where a function is outsourced, those issues are, under the orthodox view of the law at the moment, for the service provider to deal with, not the customer, unless the service provider and customer agree otherwise, which doesn't tend to be the case. As many predicted, the case has just been rejected by the CAC, primarily on two grounds. First, the CAC said that even if the University of London substantially determined pay and conditions for those individuals, the individuals were simply not workers of the University of London as required by Section 296 of TULCRA. There was no direct contract between the individuals and the University of London. The second reason for rejecting the claim was that to allow the application would, in the CAC's view, simply transform collective bargaining, and not in a good way. Further, collective bargaining with two employers would lead to chaotic workplace relationships, in the CAC's view, and it's hard to gainsay that, certainly. Whilst the rejection of the case by the CAC is clear, as I said at the beginning of this section, I don't necessarily think that's the end of the case, because this is hardly unexpected. The CAC did not deal with the Article 11 argument raised by the union and stated that expanding statutory recognition in the way the union was seeking was a matter for Parliament, and any tension between Section 296 of TULCRA, which requires there to be a direct contract between an individual and an employer for collective bargaining purposes, and Article 11 of the European Convention on Human Rights, the right to freedom of association and assembly, will be a matter for the High Court. So I think these statements very definitely leave open the possibility of a trip to the High Court in this case, should the union decide to take it further. And as I say, since I imagine the outcome of the CAC was not exactly a surprise to the union, one has to assume that they are in it for the long haul, and there will be further litigation in this area. So again, very much a case of watch this space. Although it's potentially an uphill struggle for the union, I think it's going to be an interesting and important case for employers and the outsourcing sector generally.
Do you think customers in the outsourcing sector will be looking to cover off this risk now, or do you think
a little bit difficult to see how you would do that? Because if we're talking about the imposition of statutory duties, to bargain, the recognition would be jointly against the customer and the service provider. It's a little difficult to see how you could guard against that. But given the atmosphere outsourcing seen as being problematic, you have Carillion going down, and you have the Labour Party talking about ending the PFI racket or whatever it is they call it. Maybe they're beating a drum that a lot of people will listen to.
And there was certainly a lot of press about this case. From the perspective of the workers and what they were experiencing at the University of.
So it may well be it's something that what we see is it's actually as much a political campaign as it is a legal campaign. So that's our cases for today. Thanks very much for listening. It'll be interesting to see how many of those do produce the sort of changes that we've talked about today, or at least potentially could impact significantly for all employers. Take care of yourselves, and I've got a regular podcast that I'm doing at the end of this week, so lucky people, there'll be 2 podcasts this week for you to listen to. Thanks very much indeed, and Miriam, thank you very much for helping with this podcast.
Thank you. Bye everybody.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.